they release, I shall feast and release till it is cease. Ain't no peace once you speak, ain't no cease when you at me. Controversies, what you seek when you can't keep your words sweet. Taking leaps at first chance to point hands at my name. So you aim to make shame and inflict and bring pain. But I choose to stay strong in this game and stay long. I shall reign in my songs on the lame that step wrong. I shall feed on their souls, they shall see just how cold I'm gonna be when I control, bring their knees to their toes. I refuse to go down in the book as a loss in the game. Won't complain, I just stain on the lanes I'm retained.
I wanted to touch on the basics about a trust law, okay? From the IRS website, as you can see. I don't want to, I've been listening to a lot of audios and podcasts and stuff like that, and I do my own studies too. That's how anytime you go into a podcast or any type of audios and stuff like that, and based on what you studied on your own, that's how you can determine whether or not you're getting bad information or not. Okay, so it's always good to make sure that when you're studying something, you're going to a credible source that's going to teach you what it is that you're doing. What it is that you're trying to find out. And when you're talking about the IRS, you already know that's a good source for you to go and try to get the rules to the game, okay? Now, let's start off with what is a trust. Most of us, if you don't already know, you can look at previous videos that I made about a trust. But a trust is in there, but what the IRS say, it says it's an entity created and governed under the state law in which it was formed, okay? It says, I looked into Georgia. I'm gonna finish reading this real quick. A trust involves the creation of a fiduciary relationship between a grantor, a trustee, and a beneficiary for a stated purpose. That's gonna be like the indenture or whatever the trust agreement is, the terms of the trust. That's what it is, a stated purpose. So a trust may be created by any of the following methods. Now, this is some people tell you don't have a real trust if it don't this. You don't have a real trust if it don't that. This is what the IRS says. So a trust may be created by any of the following methods. A declaration by the owner of property that the owner holds the property as a trustee. Me myself, I thought about this here when I was talking about, the authentication of the birth certificates and stuff like that. And they tell you got to put an affidavit onto it. I thought about this, what this would even be, it would be kind of related. You put in an affidavit, put a declaration on there, and then you actually kind of grant it over to your trust. And then you'll make it trust property. And you get your witnesses, 2 witnesses and a notary. Technically, that'd be 3 witnesses if you're counting the notary. But, to notarize it, sign it and notarize it, and you get it recorded into the county recorder's office. Now you got proof, you got evidence on the record that the declaration was actually made. But anyway, that's just something I thought about. Anyway, you do what you feel works best for you. Okay, and you have a clear, better understanding or something, a better route, go for it. I don't care, it's up to you. We just kind of just like just sharing some information. Okay, a transfer of property by the owner during the owner's lifetime to another person as a trustee. Okay, it says, now keep in mind, got that word "or" right there, so that means it could be any of the following methods, created by any of the following methods. Doesn't mean you got to do all of them. It means it could be one or more of them. It could be just one, and you still got to trust. Okay, the transfer of property by the owner by will or by other instrument taking effect upon the death of the owner in trust to another person or as a trustee, or an exercise of power of appointment to another person as trustee, or an enforceable promise to create a trust. Okay, this one here, this sounds like more like even a power of attorney. Some people put together a power of attorney when they create a trust. It is the power of appointment. We used to talk about that back in 2019. But a lot of us are talking about, you can appoint the judge. Remember that video I did years ago? It's called Appoint the Judge and whatever. I said something about appointing the judge. But I wasn't in a position to do that. got to create a trust. It don't come into play till you actually create the trust, And I didn't, you can't do that as a straw man trying to do a damn. I mean, I wasn't acting as a straw man, but I wasn't on the record acting. I wasn't acting as a trustee over my own trust either. Hell, I didn't even create a trust to this year. So, not one that was really, recognized, not a good one, But anyway, back then, I was just pretty much stating on my paperwork that, I'm the living man and I'm, appointing the judge. The thing was, they never would throw out the case. They didn't throw it out. What they did was they kept I was to use the 56 for the form 56 to throw the, to kind of and send it to the judge or file it into the court case. Or I would even use something like what was that damn thing called? Gosh, what's the name of that damn letter I would use? Rogatory letter. That's what I would use, a rogatory letter to appoint the judge, and give him instructions to, to settle the matter, to settle the case and all that stuff. They wouldn't do the shit. Really, they wouldn't do it. But they couldn't put a warrant out for the straw man for failure to appear because I filed that on the record. Because keep in mind, an appearance is not simply going into the building. It's not only going in the building. It's not, that's not the only way you can quote unquote appear. Because keep in mind, it's not the appearance of the living man, it's the appearance of the straw man. But it has to appear in some type of way. Whether you want to go in there in human form and act like a straw man, or you could file some paperwork on the record, and then that keep you from getting a warrant put out for your arrest. So that's what happened right there. So power of appointment, I did that. They called myself trying to exercise that, but I didn't have a trust put in place. So they wouldn't throw out the case. They did after the third time though, and I can show y'all that. But after the third time they did. I wish I could pause it. I'm screen recording this, but I can't pause it. They only have a stop button, so I'm not gonna bother. But that court case, I can still pull that up right now to this day and show where they forfeited the bond on the case. The bond was in the straw man's name too. So they forfeited the bond after I did the third letter. I sent it to him, put that and try that rogatory letter on after the third time with a notice of liability. Sent it to him in a private capacity, the judge, the attorney, and I filed it into the court case, and I still stayed my ass at home. So they forfeited the case. So after their third try trying to get me in the courtroom, they forfeited it. Okay, now, but anyway, power of appointment, they wouldn't shut it down in the beginning because there was no trust in place. You know what I'm saying? There was no evidence that I was operating as a living man, being a trustee over my own, operating in trust. Okay, an exercise of power of appointment to another person as trustee, which is what I thought I was doing, but I really wasn't. What I was doing as a beneficiary, so I was really messed up. Anyway, or an enforceable promise to create a trust. Okay, now, so exercise power of appointment to another as trustee, or an enforceable promise to create a trust. So these are the methods of creating a trust. Okay, all of these methods right here. Now let's see. So who's the grantor? The grantor of a trust. We already know that. I said this before. That's also known as the creator, the settler, or trustor. I like creator better. That's actually biblical. So I like the word creator because it said that's what it is. A grantor is creator. You're the creator. Don't the Bible say that we're all gods? Is God not a creator? Are we not supposed to create? Living men and women create. Okay, is the creator of the trust relationship and is generally the owner of the assets initially contributed to the trust. Say the grantor generally establishes the trust instrument, the terms and provisions of the trust relationship between the grantor, the trustee, and the beneficiary. These will usually include the following. Now, this is the agreement. Now, I say the grantor generally establishes the trust instrument. That's the trust itself. The terms and provisions of the trust. They write out everything, the whole rules, everything is of the trust, the relationship between the grantor, trustee, and the beneficiary. Now, saying these usually include. And it doesn't say they don't say they always include. It say they usually include. They don't say they must, they say they usually. So it can, but generally they're gonna have these in there. It say the rights, duties, and powers of the trustee, distribution of distribution provisions, ability of the grantor to amend, modify, revoke, or terminate the trust agreement, the designation and selection of the trustee or successor trustees, and the designation of the state under which the terms and provisions of the trust agreement are to be governed. They will both say they will see that anyway when you get it notarized, because you're gonna get it notarized in the same state anyway. Everybody, saying the notary stamp is gonna have, the county and the state and where it got notarized. So anyway, but you can still put it in there. It's up to you. Let's see. It does say usually. It didn't say must. That you ain't like you gotta say state of this or state of that, or John, Washington. I don't know. This is what the IRS say. So whatever makes you feel comfortable, flow with it. Because I ain't challenging the IRS on what they saying. This is a credible source, so I'm not gonna play with it. Let's see. See what trustee fiduciary. What is a trustee fiduciary? Keep in mind, remember we used to say that the judge has a fiduciary duty. They were talking about keep in mind the straw man is a trust too. It's a collection. It's a collection of all the property that's connected to that name. That's what the estate is. That's a collection of all the properties collect all together, and it's it's in a trust. And while you're a minor, as long as you have minor status, they're the trustee over that. And / fiduciary, but most of the time they do things to get to make sure they get paid. The state gets paid. Okay. Trustee obtains legal title to the trust assets and is let me pause right there. Legal title to the trust assets. Say you got a car and it says state of Georgia and it has your straw man name up under it. They actually got they got certificate of title, but it's registered. You got to register it in that state where you live at. They don't want to have legal title to it. Of course, they let you're more like a custodian of it. They give you you have some interest to it now. They may see, you may be deemed the owner of it, but at the same time, they're operating as a trustee over it until you are able to get away from the minor status. Matter of fact, let me go to minor so y'all can understand what I mean by minor. What is that? 31 CFR 63C. Okay. Right here, a minor. A minor means an individual under the age of 18 years. We thought that's all it was. See, the term minor is also used to refer to an individual who has attained the age of 18 years but has not yet taken control of the securities contained in his or her minor account. Hold on, say minor account. Minor account means an account that a custodian controls on behalf of a minor that is linked to the custodian's primary account. See, when you create your trust, you're supposed to also get you a trust account as well. Get your trust account with a bank. You can open up your trust account at certain banks that people advise. You do your own research on which ones are the best ones to go to. Open up your trust account, and now you're able to do business with, operate privately with the Treasury, and then you start, able to get control of your, the securities and all that good stuff. Anyway, I'm not gonna touch on that yet because I ain't walking in it yet. I'm on my way though. I understand that part. So I got my trust created, got it recorded. All I gotta do is get an account and go ahead and get it popping. But anyway, that's how you get out of the minor status. I just wanted to show y'all what minor is, so that you won't, you won't be limited in your thinking about a minor. Matter of fact, it says it right here. Minor account custodian. Say primary account. What's the primary account? It means the account that you establish when you first open your Treasury Direct account. See, you gotta get your account with Treasury Direct account. Say your primary account is the portal used to to open and access all your linked accounts. See what I'm saying? So you have to be able to, that's how you get out of minor status right here. Get out of minor status when you first reach the age of 18. Most of us, if you're watching this video, you're probably past 18. And then you got to create a trust. Create that trust. Once you create the trust, now you can actually, you become the you get out of minor status right there. Forgot what made me go off on that tangent about a minor. But you got to get out of that. But anyway, I was thinking, yeah, that's what it was when I was talking about, appointing the trust, basically the judge operating as a trustee, but he's trying to switch places as a beneficiary, and he wants me to be the trustee and all this good stuff, and want me to take on the debt and all of those stuff. He was really the judge is over the trustee fiduciary over the minor account, only because they only pretend to be that. I mean, they're that position anyway over the straw man account anyway. You're supposed to be operating as the beneficiary for that account, especially if you're operating as a minor. You're supposed to at least know that you're the beneficiary, even in minor status. You're supposed to at least know that. But when you create your own trust and you become the trustee over that trust is not the same. It's not the straw man trust. It's your own trust that you created. Okay, and then it's not on public. It's not okay. It's supposed to be private. Okay, let's see. The trustee obtains legal title to the assets and is required to administer the trust on behalf of the beneficiaries according to the express terms and provisions of the trust agreement. The fiduciary is an individual organization charged with the duty to act for the benefit of another. A trustee is a fiduciary. Okay? Now, the public officials are supposed to be operating as trustees over the straw man. But when you reach the age of 18, you're supposed to actually create your own trust, and you take the straw man and put it inside that trust. And when you taking a straw man and put it inside the trust, now you're supposed to create your Treasury Direct account, and you start actually operating like that through the Treasury Direct. And that's how you're no longer operating as a minor. Okay, now you've reached the age of majority. You're not a minor. Then you're operating as a trustee over your own trust that you create. Okay. Now you're fiduciary and trustee over your own trust, the trust that you created, not the straw man. The straw man is inside your trust. You took control of it. You have the ability to do that because you have an interest in it. You have interest in it. Some people are like, oh, you can't take control of something that you didn't create it. I'm like, you are the principal in the first place. Why? What make them think that you have you can't touch it at all? It's for your benefit once you reach a certain age. That's part of the indenture, right? So you're supposed to take control of it once you reach 18. Once you reach the age of majority. Now they can't do that. They can't do that if they're under 18. You can't do that. But once you reach the age of 18, you're supposed to take control of it. Okay, that's why they showed you the instruct. That's why they showed you what it was, and they used that sentence to start off with. See, some people have reached the age of 18, but they haven't taken control of their minor account. So you can be over 18 and you haven't taken control of your minor account. They're still going to see you as a minor. You're still a minor, even though you can be 55 years old. You're still a damn minor in the eyes of the law because you have nothing to prove that you've actually gone through what I just showed you about the minor accounts. What you're supposed to do. You're supposed to do that. If you haven't done all this here, then they're going to see you as a minor. Okay. Now, say, what is a complex trust? Let me see. Am I going to go through all this whole thing? Do I need to go through the whole thing? Probably not. But I want to kind of go through the basic, really. Because I don't want to make this video too damn long. It's probably longer than I really wanted it to be in the first place. I'm kind of studying while I'm reading this at the same time. I just got off the phone with my boy Vince. Shout out to Vince. That's my big dog there. But yeah, you know, I'm just talking to him about this trust and different stuff like that too. But I'm pretty much kind of looking at some other stuff while I'm going. I don't want to kind of get into a tangent about things that I really don't want to talk about on YouTube. You know what I'm saying? I really don't want to do into too much of that. I probably done said too much already on this damn video. But I'm gonna let me see what I'm gonna do. What is a grantor trust? Oh yeah, I'm gonna touch on irrevocable and revocable trust, and then I'm gonna end it. Okay. Now, a revocable trust, say in a revocable trust, by which by its terms cannot be modified, amended, or revoked. That's why they call it irrevocable. Like irresponsible is someone that's not responsible. Irrevocable means you can't revoke it. Okay. And see, for tax purposes, an irrevocable trust can be treated as a simple, complex, or grantor trust. Okay, depending on the powers listed in the trust instrument, depending on how you word your trust. Okay, say a revocable trust can be, may be revoked and is considered a grantor trust. Is IRC subsection 676. State law and state law and the trust instrument establish whether the trust is revocable or irrevocable. You have to state that when you create your trust. You got to state in there whether it's going to be revocable or irrevocable. And once you state it, it stands. Okay, if the trust instrument is silent on revocability, then most states consider the trust revocable. So if you don't even mention whether or not it's revocable or irrevocable in your trust, it's most states gonna automatically say they're gonna deem it revocable, which gonna give them the leverage to even if they find you're losing on a court case or whatever, they can go ahead and pierce the trust and go ahead and start kind of doing what they want to do. That's what I've been kind of wrestling with as far as like the revocability, or whether revocable or irrevocable. Do I need to make my trust revocable or irrevocable? That's something I've been kind of wrestling with. I want to be able to make changes to it, but at the same time, I want a solid foundation on a trust that I actually that nothing can be changed in it. So that's probably why I probably just make one of each. You know what I'm saying? Because I already have one, but I want to go back and I probably just made. I may even go back and amend my original trust and just kind of make it revocable. Just change it all together and just make it revocable. And then, go and create a different trust that may be revocable. Depending on what you're trying to do with your trust. It all depends on what you're trying to do. But anyway, anybody knows my story know what I'm trying to do. But anyway, so I ain't gonna get off into my drama. Let's see. I'm not gonna go off into these questions right here. I just thought I'd make this little video, basically kind of go over the basis of trust law according to the IRS terms, what they say. So I'm not here to debate what they got to say. I'm trying to learn from them. Okay, trying to learn from them. I'll probably get off into those EIN numbers a little bit too, but I'm gonna stop it right here on trust law. All right, y'all hold it down. Emrose signing out.